October 6th, 2009 to order. I do want to make it known that we definitely still want to take public comment on specific issues. It's a public hearing, and we're both legally required, but also required by our own conscience to be able to listen to you. Of course, we want to also be able to get into some of the issue by issue. So when you turn in a speaker's card, maybe what you could do is say if you're commenting on a specific issue, say how many what locational requirements there should be, whether or not there should be the less time for non-conforming dispensaries to come into conformance, or any number of other issues that have come up, spatial requirements, or if you have a general comment that you want to make at the very beginning. So if I could get those comments, and I believe that Mr. House, you're ready to present a couple additional aspects of this.
Sure. There's based on I'm taking this right now that we're in a continuation of our conversation from before. And as I looked over my notes from the public comment, there were a couple of things that kind of jumped out at me. So just to recap, what we came up with at the last meeting was shortening the process for the non-conforming dispensaries, the idea of a cap on the total number in the city of Santa Barbara, the idea that they would be geographically distributed, not all clumped into one neighborhood or another, but that we actually look rationally, if you will, at a map and begin to see where we'd be able to have a distribution of the half a dozen or so maximum dispensaries that would be in the community. And there were two other things that came up for me after listening to the testimony. And one had to do with the concerns that the schools, Dr. Sarvis and Dr. and John Becchio from the junior high, that they had. And so I've had some conversations since then with them. And and I believe that we should set an age limitation for access to the dispensaries themselves. We do this with adult beverages, with alcohol, and right now the limit is 21 years. And I think that I'd be willing to propose for our consideration that no one under 21 would be allowed into a dispensary in the city of Santa Barbara. And that doesn't mean that someone under 21 wouldn't have access to the medicinal benefits based on a doctor's recommendation, but the dispensaries themselves would be off limits to somebody who would be under 21. And the purpose there would be to address the issues and concerns we have on the campuses. Now, my conversation with Dr. Sarvis, their real issue begins because 18-year-olds are still high school seniors in many cases, and that has posed a real problem on the campuses of the schools. So for him, 19 would be just fine. I think it'd be very easy for us to enforce the legal age of drinking with regards to the medical marijuana dispensaries. And the other piece, the second piece that I wanted to introduce today for our conversation is to be very specific with what we mean by proximity to residential with regards to mixed use. And this was a hard one for me because I'm just thinking about people who occupy a mixed use building right now, who are residences there, and for whom this would be quite a surprise to have a new dispensary pop up, and it's not part of the CCNRs that they've signed on to. So for existing mixed-use arrangements, I have a very strong concern about allowing a dispensary in that close proximity to the homes that would be part of the mixed-use development. For new mixed-use situations, looking forward now, it would seem that all that would really be required would be some kind of advisory that would be built into for anybody who's buying into a new mixed-use environment, that they would know that there's a dispensary on the site, and they would take that into consideration when they are making a decision to purchase or move in. So those are the two things that I wanted to put on the table. The one has to do with an age limitation, and the second one has to do with including mixed use in our consideration of residential, which we had not done before.
I'm clear on the first one. The second one, I am less clear on what you're proposing. I think this is, of course, to do with the matter of the one on Chapala. Mr. Wiley, if we make changes to the ordinance that are effective, say after a planning commission hearing and a council hearing, if we make it effective at that time, it would not affect the application of what's coming in, so that would then therefore be a new category of non-conforming. So if we had a new category of non-conforming, could we treat, but is regulated, would we treat that a little bit differently than the non-conforming that existed before the ordinance, or can you illuminate how we might handle that?
Yes, Chair Williams, I think we can make distinctions like that. We have been advising both the staff and the city attorney's office that the reconsideration of the city's existing ordinance be well known, or that new applicants be told about that reconsideration and be told, in fact, that these new amendments may be retroactive. So in this context, for example, we could have actually have some retroactive provisions with respect to mixed use, and possibly even not even allow a dispensary in a mixed use building and have that retroactive. I think our inclination is to suggest that it be retroactive to July 28th, which was the Tuesday that this subject was referred to the ordinance committee. Alternatively, we could have a different sort of amortization for anyone that was approved while these amendments were being considered, and perhaps make that shorter than the original 3-year amortization, that sort of thing. So there's just a lot of different ways we can approach it.
And so what exactly are you're mentioning? Two different things between existing mixed use and mixed use that happened in the past. Can you go over that again?
Right. This is imagine that okay. So just for summary for Mr. Francisco, I'm adding to what we discussed from last time. We had the shortened process for non-conforming. We had a cap presented as a possibility, and I support the idea. Half a dozen or some number, I'm not sure what the right number is, and a geographic distribution throughout the city so we don't have a concentration in any one particular area of town. I'm adding to it the idea that we would actually have a restriction on persons under 21, under the legal drinking age, but under 21, from actually going into a dispensary, to address some of the concerns, many of the concerns that we heard last time. And then also a restriction on the on placing having a dispensary open up at an existing mixed use I want to say facility, but building, where you have residences would be directly adjacent to the new dispensary. And I was making a small distinction that we're discussing right here, right now. This is the sort of the wrinkle in it. I could imagine that there would be a new mixed-use building built somewhere within one of the zones that we talked about that we would have on our map. And it would be that in a new project, that there would just simply be an advisory to those who might move in that this is a possibility, that there could be a dispensary there because it's one of those, it's in that zone. The idea is that if somebody were to purchase in that environment, they'd do that with their eyes wide open. They'd know that that could be a possibility, and it would be an informed decision, distinct from the kind of projects that we might have already up in existence, mixed-use structures that could be in one of those zones, where it would be very likely a surprise to those who are already living there. That's the distinction I was making, Mr. Williams, and I don't know if we can get there from here, but it seems like there's some validity to that idea. So,
Mr. Francisco.
Thank you, Mr. Chairman. I want to talk a little bit about the context in which we're discussing these issues. We have, over the last few weeks, heard a lot of public testimony from a lot of different people. We've heard from school districts, we've heard from parents, we've heard from operators or potential operators of medical marijuana dispensaries. We have gotten, I believe, far more input from the community and far more varied input than I believe we were expecting, and that I believe that the City Council expected at this level. I think what's happening here, it's a couple of different things. Partly, it's the community's experience with some of the existing dispensaries.
The non-conforming.
The non-conforming. It's the prospect of the new ones coming along, some of which seem to be under the operation of sincerely motivated business people who are trying to do something different than what has come before. We're also operating in a very changed and indeed charged legal environment. Just in the past couple of weeks, there have been some very interesting decisions clarifying what the Compassionate Use Act is actually about, or at least what the courts believe it to be about. For instance, the decision last week in the Second District Court of Appeal on a suit against the City of Claremont, which had banned dispensaries outright, a suit against the city by a dispensary operator, and the city's position was upheld in a published opinion. So at least now it appears that the appeal courts are interpreting the Compassionate Use Act so as not to actually compel cities to have dispensaries at all if they don't want them. Another interesting development is the City Council in Los Angeles just passed an ordinance that seeks to comply with the intent of the Compassionate Use Act by describing what a patient collective is and regulating that. And again, explicitly saying that dispensaries per se were never discussed in the Compassionate Use Act. They don't exist in any state law, and therefore the City of Los Angeles, their intent is to meet the needs of the legitimate medical needs of patients who need marijuana for pain relief, but not to allow the operation of dispensaries. So I think we have a combination of, obviously we have tremendous interest from the community and widely divergent viewpoints. We have some pretty momentous decisions made both at the judicial level and at the legislative level just in the past few weeks. And I think what we really should be doing is reporting honestly on this feedback and these events back to City Council and saying, are you sure that this is the direction you want us to pursue in the light of these circumstances?
So you're suggesting to bring this back to council and not make any recommendations at this time?
Exactly. Based on what we've seen from the public and based on what we're seeing in the public square, I think we need a firm direction from a majority of council members before we proceed with the minutia of a dispensary ordinance.
I guess I do have a problem with that. I feel like that delays further. I don't like the idea of doing actions retroactively, though I do like the idea of taking decisive action quickly. For me to take an action a few months from now that's retroactive to July seems like we are changing the rules midstream. Instead, I would like to, as quickly as possible, change the rules appropriately for the city. And to me, what I would really like to see is to see us report out our recommendations. If we cannot reach all of the recommendations, that's fine. But today I would like to be able to report out recommendations so that we can send that to Planning Commission and back to Council with all due speed. I think us punting back to Council, will have the inevitable effect of having Council have another debate, which means that it has to come back here because that's our procedure, and then it has to go back to the City Attorney to come back here. So I mean, I
understand your
I
point.
completely think that you're trying to move this, and I think that you're making some good points that this is very dynamic. I just am afraid that would add another month onto the process.
Okay. How about this in the spirit of compromise?
Sure.
So we go forward with what the existing direction is. I'll participate in that. But we also report back to council today the sort of thing that I've just described, assuming that both of you agree that that is indeed the sense that we're getting from these hearings, that there are some larger issues in play that we believe the entire council needs to look at.
Absolutely.
If we have agreement on that,
I do believe that.
Okay.
And I think things are, I think even by the time it comes to council, we may have a little bit more information that will inform our decisions. But I do think that there are some very important things that we've been discussing and that the public has brought to us that we should take some action on.
okay.
Again, if there's any public comment, we have discussed various different changes to the ordinance thus far. We have already, in the last hearing, made the recommendation that we will shorten to 6 months the amount of time that non-conforming dispensaries have to come into conformance with our ordinance, which was previously, I suppose, 18 and a half or 19 months left. And that will mean that the ones that are currently non-conforming either need to move to a place that is not within 500 feet of a school or park, or they will have to go out of business, or they will have to reapply at a place that is appropriate if they have a place that is appropriate. And we talked last time about a cap. And so that being one of the larger issues, I think it's important that we talk about cap, that we talk about whether we do want to have you wanted last time to talk about the issue of the moratorium, and I definitely want to talk about that. And what kind of moratorium that you wanted to talk about. And spatial considerations, because people continue to ask for more spatial considerations. So let's and then Grant has brought up two other issues. One was age limits, and then the other is the issue of mixed use buildings. So can we, because we came a little bit in the middle of the discussion of mixed use buildings, I'm still a little bit unsure of what you're proposing in regards to mixed use, Grant. Are you saying that we should ban it from buildings that are mixed use previously but not into the future?
Yes. The idea being that this has very much to do with the idea that somebody who's already living in a mixed-use structure is a very special kind of thing. I mean, it's like a neighborhood that's adjoining that we have in our existing ordinance. We talked about neighborhoods, residential neighborhoods. In the situation where you have a mixed-use structure and you already have people, families, individuals living in the structure, and then you have, as one of the allowable uses, a marijuana dispensary. We've heard from neighbors in a situation like that, their great concern. Now, whether it's founded or not, we don't have statistics. We just don't know. We know that they're concerned, and there was no way for them to be prepared for that or have any way to know about that in advance. So I want to address that concern in the first instance. So mixed-use buildings would be off limits, the ones that exist already. Secondly, the second part, to really address that concern going forward, it would just simply be necessary and of course they could have their own CC&Rs that prohibit it. For instance, the one on Chapala Street, I think, already has a CC&R against head shops, whatever that means. which doesn't really apply to this because it's not the same thing, but they already built it into their own CNRs. But for the future, at least from the city's perspective, where you have residences and commercial in the same structure, we would require that there be a notification included with the for whomever is going to live there in the future that this is a possibility, that there could be, it's within an area, one of those areas that we've defined, where there could be a medical marijuana dispensary. That's an advisory going forward. And we could make it just a ban altogether, but I'm concerned because if you look at Upper State Street as an example, there's places up there that very likely in the future will be mixed-use areas right along the street. It's quite likely, and it could very well be the right place for a medical marijuana dispensary. I just want the residents, the future residents of that kind of a environment to have had a heads up so they know that that could be coming.
So your proposal is to ban it from existing mixed-use buildings, but to permit it in future mixed-use.
That's right, because it gives protection for the people who are already there, and their own mind's sake, they have their rest assured that that's not an issue. They didn't make that agreement coming in. But for the future, since mixed use is going to be quite a lot of the new development that we see along the places that we're likely to have on our map, we would be giving people a heads up that they're within that kind of a zone and make an informed decision. Doesn't mean that there couldn't be on each of those properties their own CCNRs that they come into an agreement with. That would be up to them, but they would at least have had that advisory moving forward.
Mr. Francisco.
Thank you, Mr. Chairman. Mr. Wiley, a question. The mixed-use ordinance, so-called, is scattered throughout the zoning ordinance, and I'm not aware of any, this is just a question, I'm not aware of any other restrictions on particular commercial uses that can coexist in a mixed-use building. Are there any, and are you aware of any such restrictions in other jurisdictions?
Councilmember Francisco, no. Councilmember Francisco, I'm not aware of any use restrictions like that in our city's mixed-use ordinance, and not aware of any other cities that do that sort of thing. I think maybe it's obvious, but what we're dealing with here is a type of use that a lot of landlords would not be interested in renting to. Frankly, it's not dissimilar from the situation for adult businesses. In other words, most landlords will put covenants in their on their property, commercial properties, saying there will be no leasing or subleasing to head shops, to adult businesses, that sort of thing, and they've dealt with it in a private way. It's, it doesn't become a city zoning issue. And I think what we're dealing with here is, particularly, with recently constructed mixed-use buildings, the landlords and the lawyers drafting the CCNRs didn't think of this. And so now we're dealing with it. And I think Mr. House's point is they will think of it in the future. They'll deal with it. They'll either put a CCNR or a covenant in it that says no medical marijuana dispensaries in this building at all, and so when the developer sells off the commercial space, it just won't even become a possibility. But we've got this window period, if you will, of existing mixed-use buildings that didn't anticipate this issue and don't have it in their CCNRs.
The second part of my suggestion may not be absolutely necessary. The first part, I think, is important. The second part would be, it'd just be very likely that if that, now with this sort of a heads up, the private property owners could make that a provision, and then that would be, would fulfill. I don't know if the city has to get involved in it. The first part's the one that's most of concern to me. I do believe that at this particular point, there's a chance that there could be proposals for medical marijuana dispensaries in mixed-use places where there hasn't been a chance in advance to consider this as part of the CCNRs or whatever. And I think that it's important for us to make this provision and sort of settle the minds of the people that have come and talked to us, and we've heard quite a bit from them. For the future, I guess my second piece isn't that important if I really think about it now, because private property owners who will be in an area that would be where this ordinance would allow for dispensaries, they'd have a heads up anyway. It'd just be a natural part of doing business. But anyway, I clearly wanted to put this on the table for us to discuss and see what you guys think. The first part's really important to me. The second part isn't that big of a deal.
Well, I think that what we need to do, because we're policymakers, is we have to think about it and in outside of the context of one specific case. Sure. I mean, we have to, if you want to ban it from mixed use, that means that potentially in the future, because we are trying to incentivize mixed use, that most of downtown would become more and more off limits. That most of downtown would no longer be available as a dispensary, because we have pyramid zoning, which means that any commercial property can go to residential. It's considered the preferred use. So it means any commercial property can become a residential use, which means that all commercial could potentially be then off limits.
I want to be crystal clear. I'm absolutely not saying that we should have a prohibition against medical marijuana dispensaries in mixed-use development. I'm saying that existing mixed-use development should be off limits, and I think we need to really make that clear, because that has been the issue. Whether it was one example of that made me think like this, or another. I think that's that addresses a class of. I mean, I can think of a place over on Milpa Street that's might seem like a perfect place for a marijuana dispensary, and it's a mixed-use environment, and I think that those tenants wouldn't be served if we were to open that door for them. I think the concerns would be the same as we heard from the concerns over here in Chapala Street. So that's the reason why I bring it up. And again, this would probably only affect a very small number that would be particularly in a zone, in an area that would be on the circle on a map of some sort. But it would really, I mean, we have these hearings for good reason. We want to hear from people and hear their concerns, and I think we should try to address their concerns in the ordinance. Looking forward to new mixed-use development, which is going to be more and more prevalent, that's a different thing, because everybody will have a heads up. They can make up their minds if they want to move into a place that would allow that or not. That's up to them.
And Mr. Wiley, you've seen nothing. It seems strange to zone for one way for existing buildings and another way for future buildings. Do we have any concern for that?
No, I think that's workable. That in essence, there would be a sentence or a paragraph in an ordinance that said, mixed-use buildings in existence on the date of the adoption of this ordinance shall not be eligible to be locations for medical marijuana dispensaries. And that, as you know, when you think about it, that only then would apply to buildings in existence on that date. And then in the future, it would be up to the developer initially to impose a covenant against medical marijuana dispensaries or not, up to the developer. And then, so everyone buying into that project at that point would know exactly what they're getting, presumably because they get a copy of the CC&Rs and they look at their CC&Rs. Again, I think this is just something, it's such a new type of use that your typical CC&Rs and the lawyer drafting them didn't think of dealing with this issue.
And then my other question, under your proposal, Mr. House, what would happen to an existing, or as I understand, one mixed use that's in existence that's non-conforming, and then there is one that is in the project pipeline? What if that is approved? What would happen to those two? Would we give them a certain number of years, as we have given other ones, to comply to the ordinance?
I would really need Mr. Wiley's assistance on that and how that would work out exactly, because I don't know. Again, your advice on retroactive helps us a little bit in understanding people have been given notice that we're in the middle of this process, deliberating on this with direction from council. So it's no surprise. I would really need some help from you as to what would be possible there. There should be a fairness component to it, of course, but at this point, I guess it depends on how deliberatively we move forward, right, from today, whether we were to finish our deliberations today and send it off to council or whatever. But Mr. Wiley, what do you think? I mean, is there, how would that work if there were an approval of one or another situation like that in the next few weeks? What would we, before this ordinance were adopted, how could that work? Would it be required?
We would
it be
have
necessary
essentially
to have a
two choices. We'd be able to either make it retroactive or make it current, which would be render the use non-conforming.
That's correct, but there's actually in a lot of variations in that. We could make it retroactive, and I have to say that retroactivity has been something, particularly for zoning amendments, that the city has used, in my experience, for years. Even in the late 80s, when we imposed essentially a moratorium on all new development as a result of the drought, we picked a date when that subject of the moratorium, it wasn't actually called that, went to the city council and said this is only going to apply from this date forward. So we didn't, we allowed the pending projects to move through the process, but then we had a date, a retroactive date, where anyone who filed after that was subject to the moratorium, the eventual, we ended up with a water lottery, a permit. That's just one example, and there's several since then where we've done zoning ordinances in a retroactive way. We don't have to do that. We could have them all prospective and then allow the pending applications, typically it would be pending applications, to move through the process under the old rules. We could key the retroactivity on the application date. We could say everyone who applied prior to July 28th, which is the date that this subject really got referred to the ordinance committee, everyone who applied prior to that date would be allowed to use the old ordinance, and everyone who applied after that date could be allowed or would be subject to the new ordinance. You don't have to use that date. You could use the date of the introduction or adoption of an ordinance. So there's a lot of different ways you can do it, including then finally just having it all prospective, but having an amortization period for anyone who was approved prior to the adoption date of a new ordinance, which is what essentially we did with the first medical marijuana ordinance adopted 18 months ago.
And then it would be up to whomever was applying for and perhaps renting a place like that, whether they wanted to make the capital improvements or whatever they felt for a fairly short duration, whether that was worth it to them. Well, that's it's one of the two. One of them is retroactive so that it's just clear for everybody and people don't waste their time getting in. You know, of course, it depends on what council does, because it's not up to us here at Ordinance. We're making this proposal, and the city council as a whole will have to make a decision. If we do it with an amortization period, there might be a lot of effort that would go into one of these things, and then there's clearly no chance to continue on in that particular location. They'd have to look out for another location, and they'd have to actually be one of the, if there's a cap, they'd have to be one of the half a dozen or whatever number we set, or they'd have to wait their turn until there was another opening. So,
Mr. Queta?
Mr. Chair, just a little bit more information about some of these existing and proposed dispensaries that might confuse or help matters. I'm not sure. The pharmacy, which is
That's definitely what we need is more variables in all of this, Mr. Queta.
It's the one that's proposed in Paseo Chapala. They applied before July 28th of 2009, so it wouldn't be the retroactive would not. If we choose that date as the date of an application coming in, then it wouldn't be retroactive to this particular dispensary if it gets approved. It's going before the staffing officer tomorrow, and most likely it'll be appealed to the Planning Commission. I just, whichever way it goes, I anticipate an appeal. The other one we heard, 100 East Haley. Thomas Byrne was the one who came to the podium last time and said, I have a non-conforming dispensary in a mixed-use building, and he's the owner of that building. That one is not allowed to stay where it is. That is within 100 feet of Veracruz Park, so that is not a viable location anyway. I just want to give you that.
That's good information, Mr. Cato. So the question is, do we want to create a ban for one dispensary that we're not even going to affect by changing the ordinance? I mean, we could render it non-conforming, but because they applied before we began our discussion, even if we made it retroactive, it would not affect the application of the pharmacy. So,
Mr. Chair,
do we enact a ban just for the benefit of one that we're not going to be able to affect?
Just to be clear, there's just a lot of variables. Mr. Cotto's remarks were they applied prior to the July date. We don't have to use the application date. We can use the approval date. We can use the date that the application is deemed submitted. There's just a lot of variables. It really kind of boils down to what you feel is both appropriate in the larger picture, zoning picture, and what's fair typically. But we don't have to use the application date as the key date.
I'll just say for my part, I'm fine with creating prospective bans. I'm fine with creating a non-conforming status and give the same sort of times and allowances that we have given other non-conforming to go forward. But I don't think it's appropriate for whatever reason. We did not foresee this conflict when we enacted the ordinance before. We didn't. We looked at a map and we said, these are the areas that we don't want it, and these are the areas that we think it's okay as long as it's not too much. So, and this was squarely in the area that we said was okay. So I'm fine with changing that prospectively. I'm not okay with the idea of changing that in the past. That's what I consider revisionism. And I think it's a little strange to toy with people in that kind of manner.
Well, Mr. Chair, just I know Mr. Francis put his light on, but there's the two pieces of fairness here are really what's in the balance. I know that for whomever has applied and is in the middle of a process is going to be before staff hearing officer or whatever part of the process they're in. There's a fairness concern, and I think you're talking about it there. The big issue of how we deal with that. There's the other one called the people who are already there, already living there, and their concerns, and that this is something, as you're right, none of us had considered. I believe, by the way, ultimately these dispensaries, if they're regulated the way we're talking about, will be seen as very innocuous and kind of like the pharmacy down the street and no big deal. I think that's how it's going to be. I hope that that's how it's going to be. But in this particular case, we have enough concern from people who show us what it feels like to be a resident in a mixed-use place with something that they're fearful of and concerned of, and that we have a chance to give them from a fairness perspective, give them some relief from their concerns. So that's the reason why I bring it up. I'm trying to think of some other alternative there, some other way of approaching this. If it is, as Mr. Wiley sort of opened the door and you bring it up, that there's a amortization time or something, it doesn't really allow for that the tenant of the dispensary to have any hope of continuing there, right? In that approach, they would have to relocate at some point.
Right, they would have to relocate at some point. It's
not like it would be, amortization would be that they're there for 6 months or a year and we'd take a look and see that it was an attractive nuisance or not and they could stay there. It would be that they would have that period of time to make arrangements to have gotten established as a business and then find some other place to be if that were even possible within our cap.
I think under the existing ordinance, we already have the ability to revoke a permit if someone violates the terms of our ordinance. So that, to me, the idea of having a 6-month review is, I don't know if that would be duplicative or not of the process that we already have to revoke a permit.
Okay, well,
But-
I'm interested really to hear what you two say with the proposal. I'm also interested in hearing about the age limit too, because I sincerely put those forward to address the concerns, both of those things, to address the concerns that we heard here at the last hearing, and I think the public deserves to have us at least chew on these two and come up with something out of the two. So,
Mr. Francisco?
Thank you, Mr. Chairman. Let me just reiterate that I think we really need to look at this problem in a larger context, and I'm looking forward to discussing that with the rest of council later. But while we're focusing on this issue, Mr. House, I think, raises the essential point that we really cannot evade, and that is that there are two sets of rights in conflict here. We have a applicant for a dispensary under the existing ordinance. We also have existing residents of that building who presumably purchased never assuming that this is a problem they'd have to contend with. So we can't get away from that one. We really have to come down on one side or the other. I think Mr. House has correctly assessed that. We have to make a decision. Now, I agree that should the city of Santa Barbara continue to say that dispensaries are an allowable land use, and it's not clear to me that will happen, but if that does happen, then the idea of letting this be dealt with in the private sector going forward makes perfect sense. It should be a matter for CC&Rs. It should be a matter between the developer and future tenants. But in this existing case, this is one that we can't get away from, because both sides have legitimate claims. This is something that I think we have to decide on.
And so what would be your suggestion, Mr. Francisco?
Well, personally, I agree that the existing users, if you will, of mixed-use buildings have an expectation of what kind of environment they're living in. So we've heard from the residential tenants, we've heard their concerns. I think we need to listen to those concerns. I believe that for existing mixed-use buildings, the city will have to act and say, we can't have marijuana dispensaries in existing mixed use, but going forward, that will be up to the developer and the tenants. That would be how I would come down.
And then what effective when and what would we do? Would we give an amortization period to a non-conforming applicant, or what would we do?
I think we're talking about a very limited number of cases here, but in fairness to an existing applicant, a short amortization period would probably be appropriate.
So basically the same time period that we've allowed for other non-conforming.
Something like that.
Okay. That I think we've beaten that one up. So let's talk about age limits. But there is some people who have asked to speak concerning age limits. So I'm going to specifically call on Patrick Formey, followed by Bill Walt.
Council members, House Williams, Francisco. Appreciate the time to discuss the event. This is really about addressing some of the concerns of the citizenry. The age limits deal with the concern that we're hearing from the schools that somehow an 18-year-old can somehow purchase cannabis, bring it back to college, and then bring it back to school and share it with their friends. The idea of a 19 or 21-year-old cap would at least address the idea of that particular person going back to school with the cannabis. At the same time, the use of cannabis on campuses hasn't changed since there has been dispensaries in town. It's important to understand that the use of barbiturates and pills have increased, and that can be addressed by some of the people who work in that field here in town. So I do agree that there needs to be some sort of age limit. At the same time, There's been a dispensary on Milpas. We've been operating a dispensary for 9 years with a nurse-administered program in a doctor's office for 9 years, 5 of which were on Milpas before DA letters were sent out. There was not one complaint of loitering, not one complaint from a neighbor, not one police call to the building in 5 years. It wasn't really until a quote-unquote, let's say Yahoo shows up on Victoria and creates problems, and that problem sort of resonates, and the stigma of that particular person then transcends to other people that are trying to do the correct thing. Also, I just wanted to address what I've heard here. I've heard here prior that there seems to be, at least from someone here I witnessed here in the audience, there seems to be the idea that there's no medical benefit to cannabis, and we're hearing this from the government. And I just wanted to bring up this report. This came out 2 weeks ago. This is a 74-page report from the National Institute of Sciences Institute on Alcohol and Drug Abuse. It's the endocannabinoid system as an emerging target for pharmacotherapy. And it clearly states here its effect in stroke, multiple sclerosis, Parkinson's, Huntington's disease, Alzheimer's, epilepsy, mental disorders, schizophrenia, and helps with the addictions of opiates and nicotine and cocaine and alcohol. And it goes on and on and on. I'll leave these as well. These are important documents. Also, since I have your attention, I also want to make you aware that the U.S. government took out a patent on cannabinoids as antioxidants and neuroprotectants. These are important documents as you judge to see whether something is banned or something stays here, because the information, whether it's something that's been kept from us or something that's emerging, is important to review. Also, there is a ballot initiative for 2010 which calls for legalizing cannabis and taxing and tolerating it in the state of California, and polls show that that's in its favor. One, potentially a perfect storm being that there's a need for money. 2, at the same time, potentially a generation, their offspring, realizing that cannabis is you know, no, I'm not saying it's benign, but at least alcohol and nicotine and caffeine create more deaths than cannabis does, and that can be viewed through the text. And I just wanted to mention, too, that also I submitted a white paper, and it really addresses the concern, again, of it going back to the schools, because really what we're hearing is that there's problems, and indeed there could be problems with some of these dispensaries, and I agree with Mr. House. If these particular parameters are put in place and these revised ordinances, this revised ordinance has the proper structure to, let's say, account for limits, and also about the reselling of cannabis, whether it's an 18-year-old bringing it to school or whether it's a member of that dispensary abusing the fact that they have a license or a recommendation, and they themselves are turning that back over to someone else. And those can be addressed. I went into specifics in the white paper, which you have, and you can look at that further. Also, in terms of the Claremont thing, I think it's important, with all due respect, to look specifically, because I have looked at that, at
Mr. Formey,
yes.
I didn't enunciate a time limit, but if you could wind up and definitely get to the age limits question,
okay.
That would be
well, the age limits,
helpful.
basically, I'll just go back to that. I agree with Mr. House in terms of there being an age limit, because as council members and members of the council, you really have to take into consideration the complaints, whether they be the minority of the town or the majority. That has to be addressed. And what we're really hearing from, and one of the larger issues, is the idea that somehow this is going back to the schools. And by setting an age limit of 19 or 21, you're addressing that issue. And unless the person is brought in by their parent or guardian, which really is something that Mr. Wiley can look at, because really at the point of when you're 18, you're 18. You can go in the Army and do that business. You know, why can't you take care of your own needs, whether it be for pleasure or for medicine? So that has to be something that has to be looked at. But the idea of 21-year-old will also comply to some federal laws that have come down on the side of, in the Morro Bay case specifically, where that was used as an age limit on a federal offense. So anyway, I'll leave you. I can speak with this materials later if you bring me back up. Some more issues to talk about. Thanks.
And I'll have Billy Walt, and I will also take public comment on the issue of mixed-use buildings, since I've got a couple requests from Paseo Chapala residents to speak to that. Mr. Walt.
Yes, Council. In all my review, I really think that having an age limit would help to control some of these issues. Although you're asking for the age of 21, with exception, I would suggest, of a parent's letter as well. In looking at the new City College newspaper, there's an ad in the newspaper put in there by a dispensary advertising. And obviously at City College there's probably kids 19 and 20. So there may be some 21-year-old who may have a doctor's letter, perhaps put in that they also have a letter from a parent to have access. In your issue about the mixed-use permit, I know that parts of the city are going to be growing here. And mind you, that is important for residences. But also when you're going to open up another zoning area, be a little bit more liberal to compensate for the development that the city is going to have, especially in the upper State Street corridor, where some of the motel hotels are going to be leaving the area. They're going to be putting up condominium complexes. There'll be a high density of people there. The other thing about, Dale, you said things about Los Angeles and reading with what's going on down there. Santa Barbara is not like Los Angeles. We don't have the crime issues and the violent issues that they've had down there at all. So I'd like you to reconsider that. Also, in the guidelines from the Attorney General of the state, he does say, specifically in there, that he believes a collective can operate within the confines of these guidelines. He specifically words that as such. And collectives have been around since the 1950s. It's a collaborative group of people. Now, they need to get their medicine somewhere. So there has to be some location, some storefront that manages that. And using the word as a dispensary can certainly be viewed differently as if it's viewed as a collective or a collaborative. I also think that, and I've talked to several people here, Patrick and Joanna, who's both very knowledgeable, more knowledgeable than me about the medical science behind this. And there ought to be some way to ask the dispensaries to provide information, to provide accurate, factual information that is continually coming out. And
thank you, Mr. Wall. We'll have Kathleen Gu followed by John Campanella.
Thank you, committee members. My name is Kathleen Gu, and I'd just like to say I do support committee members' House's proposal for excluding the prohibiting it from multi-use buildings, existing multi-use buildings, because as a resident there, I do have a vested interest. And I look at my property tax bill, and I know I definitely have a vested interest in the building, and it's my life, and I really would urge the committee to consider to ban it from existing multi-use buildings. Thank you.
Thank you. John Campanella, followed by Joanna LaForce.
Good afternoon. Thank you. One issue that we have asked about before when we first submitted our letters was that under the current ordinance, exclusions are where a dispensary is prohibited is on a parcel zoned for residential use. That's currently part of the ordinance, and we've asked that question, and I don't think it's been adequately considered, that there already is an interpretation that this was considered during the process to create the first ordinance, going back perhaps all the way to the Planning Commission comments. And I think that needs to be addressed. Secondly, the Paseo Chapala timeframe-wise existed, had its maps recorded, there was the sale of commercial. All of this occurred well in advance of the current ordinance being put into place. So this was, again, no knowledge that anything allowing dispensaries would ever come into play. And you're absolutely correct. It would have been included as other exclusions are usually handled in the CC&Rs. But without knowledge of it, you couldn't anticipate that would be done. So as far as application, the current review of the ordinance occurred prior to the application being deemed complete by the pharmacy, just as far as your chronological order. And we do support Chairman House's opinion that this should be retroactive at this point. There are other issues that are going to come up as well when you go through your process. Should you be where children gather across the street? What are the circles going to be from the parks? We're near gathering spots just like any other park is, at Paseo Chapala Mall for young people. You may have other considerations that also might come into play. So I think that as you go through that process, you're going to pick your spots, and you're going to pick spots that really are conducive. And I think they're going to be much more conducive than a spot having residential housing already in it. It's a pretty long street with not a lot of residential on it where there could be C2 used. So, again, we're still looking for response on zone for residential use, and we support Mr. House's position that it should be retroactive. Thank you.
Thank you, Mr. Campanella. And just one note, Mr. House is not the chairman. I'm the chair, and we don't use the word chairman anymore because we have a lot of chairwomen these days. Does the city attorney have any response that he would like to make on this case?
Mr. Chair, yes, and I think we've said this previously, but let me just be clear about it. When the ordinance, the existing ordinance, basically precludes dispensaries on parcels zoned for residential use, we are pretty sure we meant only the straight residential zones, the R1 and the R zones and the single family zones. That's the only thing that really makes sense, because the alternative interpretation means that you couldn't have a dispensary. I mean, with our pyramid zoning, where you can have residential uses in any zone except the M1 zone, the industrial zone, that interpretation would leave dispensaries only in the M1 zone. So that makes no sense. We don't think we meant that. We don't think you meant that. It doesn't appear to say that. We do have to deal with this mixed use issue.
Thank you, Mr. Wiley. Joanna LaForce. And I have three other folks that have public comment. The question is, do you want to do it right now or before? You can just sort of nod if you want to do it right now, or if you want to do it after we have a chance to tackle the other issues. Joanna.
Thank you for allowing me to speak. Excuse my casual dress. I was watching on television and didn't think there would be public comment available. But in the light of what's going on, I do need to stress my position and importance of this. We submitted our application May 20th, as you know. We were deemed complete. Our hearing is set for tomorrow. We have spent a lot of time and effort and money in making sure this would happen. We have a lease, a long-term lease. We have a lot of things already in place. We picked this location for its accessibility, and it was a C2 zone. I don't understand what the difference if it's residential above you or beside you. To me, the Z2 zoning was what we picked in good faith because of the area and who and what we are. To have a short, non-conforming time would not be helpful because there's a great expense in building out the pharmacy, making it available. So it's a really tough spot for us. And it's hard to think of a solution for this. I understand both sides, but I think it would be very unfair to not allow us to be a part of what we thought we were getting into from the beginning.
Sorry, Joanna. Hold on just a moment.
Okay.
Could someone shut off whatever cell phone is on?
I'm sorry. It's a bird.
Please
I just
continue.
got the phone. I don't know.
So you
why
just
it's
interrupted yourself.
I know.
Okay. Please continue.
So anyway, I would ask that that we be allowed to remain in the position that we are. I feel it would be a hardship on us, and the non-conforming. Where do we go from here? You know, is this would it be a new application? I mean, there's so many things that would be subject to not being able to be a part of Santa Barbara that need to be considered. So, thank you.
Thank you. we are on the issue of the age limitations. And you have a comment, Mr. Francisco.
Thank you, Mr. Chairman. And in the event that this committee is chaired by a lady, I will properly note that. Regarding the
Call me a chairwoman if you want. That's fine.
It would seem a little odd. I don't remember, perhaps Mr. Wiley does, in the recent Los Angeles ordinance, they had an age restriction, and I believe it was that anyone 18 or under had to be accompanied by a parent or legal guardian. Otherwise, it simply isn't allowed.
It does seem that if we have a precedent and we have one that's already seemed to work.
Well, we don't know if it works. It's a new ordinance.
Right.
But it seems like a good idea to me. It seems like a reasonable requirement to have an age limit.
And I'm not sure that we should make obviously there's still some high school folks who are 18, which is why I think LA decided to do 18 and under. Seems to me presumptuous of us to dictate that a fully emancipated citizen under our laws that is 19 would have any less capability to make these determinations. While we know that might be true in some cases, I also am not sure that that's a good idea for us to be making those decisions. And I suppose the case of 20 or 19-year-old high school students is pretty rare, thankfully. Mr. House?
Let me ask Mr. Martel. The legal age for drinking is 21, right?
And the legal age for
21.
dying in Afghanistan is...
Yeah, I know. Look, I could... Never mind. We have been able to enforce that in our entertainment district and any place that's serving alcohol. We've got it. We've responsible beverage service training and all the rest. We've managed that pretty well with alcohol, at least, right?
Yes, that's true. The downtown area is very well controlled, and we don't have problems. We do have 18 and over nights, and that is also controlled. Again, it depends on depends on the situation. Here with our dispensaries, it's also noted that under our current ordinance that we don't allow minors in there unless they have a guardian. So I think there's a control mechanism in our current ordinance.
I really do believe there will be a direct benefit to the management, in particular in the school environment, but it doesn't mean that a person under the legal drinking age couldn't have access to the substances that they need based on a doctor's recommendation. It just makes it clear and straightforward for the proprietor to know where they're going to be, what's appropriate and what's not. And a minor, or under 21, we would say in this case, under 21 just simply wouldn't be allowed in. That just makes it clean and clear and simple. Somebody would have to act on their benefit, and perhaps their doctor or perhaps adult family member or something would be able to go there, but on their behalf. But it just so clears up a lot of these issues that we heard. We really heard some pretty serious testimony. I do take our superintendent of schools, and we even heard from the county superintendent as well as our principal of our local junior high. I mean, these are people I really highly regard, and the issue was important enough. And when I talked to Dr. Sarvis, one of the most important pieces of this was how, I don't know why, but easy it is for young people on a campus to mistakenly assume, I guess, that once they get their prescription or their recommendation that they can share it with their friends or sell it or whatever. And which brings up one other little thing I didn't mention, and I should have, and that is that I believe we should also have some kind of notification on site that's very clear and visible that says that it's illegal to distribute to others what you've gotten as a recommendation and or to resell. That needs to be clearly posted so everybody can see. And on the other hand, that if it comes to light that one of the members of the collective has done that, that they need to be cut off from the collective, and more than that, if the owner of the dispensary were to continue to serve them, that they could lose their license or lose their ability to continue being a dispensary. So that what we actually have is good, clear rules. First for the age. Secondly, for this the problem that we're getting feedback from, this concern about redistributing and reselling, that there's just no question about it, and that there is a penalty for continuing to serve someone who has, or continue to serve their requests once it's come to light that they have abused their privilege. So that's something I hadn't mentioned before, and I made a note here to bring up, and I add that to the mix.
I agree with all your points, though I fail to see how that applies to someone who's 20 or 19 and not a high school student. So I'm okay with the 18 or under provision. It makes us not out in front, and I could say that I would hope that there's few college students who have the need of medicinal marijuana. I would think that there would be more people who are older who have that need, but I'm not sure that we want people to represent them coming in. We don't want resale. We want to have a dispensary to have a direct connection. Reselling is probably the biggest problem that can happen, and I think that making it apply to 20 and 21-year-olds and 19-year-olds pretty much makes reselling incentivized, because I don't think there's going to be any 20-year-old with medical problems that's going to send to Ohio to their parent to come fly out here to buy them medicinal marijuana.
Okay. Well, the 18 years old I don't think solves the problem on the campuses, because many of the kids are becoming 18 still November, December. They're somewhere right in there, and that has been the nut of the problem, according, again, to the superintendent of schools. That's
right, which is why Mr. Francisco suggested 18 or under.
Okay.
To include 18-year-olds. Is that
Actually, no. I wasn't suggesting that. I was noting that was what
the
Los Angeles has proposed, and I would be comfortable with the age restriction that Mr. House is proposing.
So do you want 21 or 18?
21.
What do you want, Mr. House?
Mr. Chair, sorry to interrupt, but I have to tell you, we've seen a lot of ordinances from different cities, and we've never seen this attempted, and there's probably a good reason for that. It's probably preempted by state law. The anomaly of different, number one, in federal law, in a way, in the federal Constitution, you're an adult when you're 18 or older, and that's, as far as I know, that's absolutely true across all of federal law, with the minor historical exception of the possession and consumption of alcohol. Just for a lot of old historical reasons, states are allowed to treat adults at 18, 19, and 20 differently when it comes to the possession and consumption of alcohol. And that's about it. When the whole approach here, and the approach that is being validated by the courts, is a zoning land use approach to medical marijuana dispensaries. And so the question would come up, what is it about an 18 or a 19 or a 20-year-old from a land use perspective that allows you to make that distinction when, for example, or in particular, look at the state laws, the SB 420 laws adopted in 2003, which are preemptive to the extent, that we can't change those laws. Why would we as a city be able to change those laws for 18, 19, and 20-year-olds? Frankly, I doubt trying to do that would be legal, in the sense that I feel it's probably preempted by the Compassionate Use Act, the 2003 statutes. And that's why, though, you see Los Angeles does, in their proposed new ordinance, require that anyone under 18 has to be accompanied by their parent or by, I believe, their physician if they go to a dispense or a collective.
The idea is not to make it so that they can't. I mean, there may very well, for ADD reasons and other kinds, there's lots of reasons why this may be appropriate for them. The issue and the nexus has to do with the testimony that we've had of 18-year-olds and others at the high school level referencing their access through the dispensaries or the resale from dispensaries when they've been, because it's illegal on the campus for them to have possession anyway. So that's a school rule. So I'm trying to bear a nexus between that concern that we heard and our local discretion with our ordinance. That's the nexus, and the direct nexus part I have is for those between 18 years and 19 years. I was thinking that we had the ability, because we do it with alcohol, to use 21 as a better number, because that's the one that's been accepted and it's easily enforced, as we've heard from the police department.
But we don't do it with respect to alcohol. The state does, and the state law on alcohol is preemptive, so that's why they can do it.
I see.
But we couldn't attempt to make it legal, for example, to drink alcohol in Santa Barbara if you were 19. It just flat out could not do that.
And so it's your advice that we can't say that, say even 18-year-olds, that goes up to 19, that 18-year-olds may not be allowed into the dispensaries?
I would
without, or even without an
strongly
parent
suspect
or
that a
adult?
court would strike that provision down as
How about
being
that?
preempted by the 2003 statutes. And frankly, it's because this is a police concern, a criminal concern, if you will. When a principal legitimately says this is being resold in the high schools, that's not a land use concern. That's a flat-out violation of existing law. And that's why, we're in trying to solve that concern, we're not really addressing a land use concern. We're addressing, and the answer may be to go to Sacramento and to get Sacramento to change the Compassionate Use Act, but I don't think we can do it on a local basis.
Well, some of us are trying to work on that one, but so the what is the will of the committee on this? I think that personally, I think the best thing that we could do on this is tighten up our enforcement provisions, because I think are some cases of actual minors getting these, in which case we want to do something about that. So personally, my suggestion would be that we have, in any cases, a banned list that is furnished to all dispensaries that these dispensaries have to keep. And this is people who have resold, people who have somehow violated the provisions of the ordinance, they're underage, whatever, and that a dispensary have some penalty for selling to someone who's on the banned list, probably the possible revocation of their permit.
Mr. Chair, let me just be sure I understand this from Mr. Wiley one more time. So the farthest we can go, based on precedent or based on your advice, is to say 18 years old, it'd be under 18, would have to be accompanied by, which we already have. Don't we already have that in our current? Okay, so we can't go any further than that, your recommendation. We can go to having clear posting at the site about reselling and distributing. We can have a very clear advisory, so there's no way in the world anybody would miss it. And because you would have, we begin to avoid the ignorance excuse when the kids get picked up at school. Secondly, this list that Mr. Williams is talking about, is that something that you feel that we could support, or that we, my feeling is we should have at least something where if they continue to serve someone who has violated this this by legally distributing or reselling, that they could lose their license. But I mean, there should be some hook there. I mean, if it just can't be that somebody, because somebody resold, no. But if they had been caught reselling and that came to the attention of the owner of the dispensary, that there be an accountability factor. That's what I'm looking for.
And I guess what I'm looking for is to make sure that that's uniform throughout the city, that it's not just, one one owner that knows that he's not supposed to sell to this person, but that every dispensary in the city is responsible for not selling to those people.
Mr. Chair and Councilmember House, I think we could achieve those sorts of things. I don't think we would be able to achieve it by a list of names that would be provided, particularly with names of minors, that would be provided to dispensary owners or operators. But we could, it's illegal. It's, all of the things you're talking about are illegal now and have been for many years, even before the Compassionate Use Act. And I have to tell you, this discussion reminds me or makes me think of what the city of Los Angeles is dealing with apparently now. There are two models to approach this, and one is a land use zoning model, and we did that 18 months ago. And you think, all right, this is the nearest parallel we have is how adult businesses are regulated, and we have an existing. But it's the same sort of, you have collateral impacts from certain uses, like an adult business or a medical marijuana dispensary. And from a zoning standpoint, you're allowed to have a zoning ordinance that deals with those collateral uses, even to prohibit the use in certain areas because you don't want them impacting residential zones, you don't want them impacting schools or whatever. But today's discussion really has focused on a different model entirely, and that's enforcing the requirements of the Compassionate Use Act, and not a zoning in a sense is a parallel model that goes along with the state law requirements, but they're very consistent. They're not in conflict, and that's why it's legal to have local zoning. And then enforcing the state law in a way that's supplemental is also another model, and that's frankly what the city of Los Angeles is beginning to do. And in part, apparently, because the LA County District Attorney is saying that he is going, in his office, is going to enforce the collective model, is going to enforce the State Attorney General guidelines for a true collective consistent with the Compassionate Use Act, and the LA City Attorney has said the same thing. I'm not suggesting that we're in a position to do that, but I am saying that what I'm hearing you discuss is an ordinance that's supplemental to the Compassionate Use Act that really gets into some of the details. And the fundamental detail is the Attorney General's guidelines flat out says the retail dispensary model is probably not legal. It's just not what the Compassionate Use Act anticipated. And what is legal is a true collective model. And for example, in the LA ordinance, it says you cannot sell marijuana. It's not about selling marijuana. It is, and they don't, it's about collectively organizing to provide medical marijuana to qualified patients and to have it provided by qualified caregivers and to have sort of a fixed group of individuals that actually and truly come together collectively. I'm really trying to say this now at this point more for informational purposes. I do think ultimately we got to decide which model we want to follow, and if we're going to do the zoning land use approach, we're really, I think, supplementing more of our existing ordinance and maybe looking at the locational requirements, maybe looking at the operational requirements, the hours and the security and the background checks, but. We've got to make a choice at some point, I think.
And we've already done it with our existing ordinance, all the things you just said. We're trying to respond to the concerns we've heard from the people who have come and testified before us, and that takes us into this other territory, is what you're saying. Do you feel that we have the ability at a local level to take that on as LA is doing, or is that something that's that you don't feel that we have the ability to really go after here? Because I mean, it seems like this under 18 thing. Okay, we've already got that in our ordinance. It doesn't appear that there's a way for us to expand that, given your suggestion, what you're saying to us. And the best I've gotten so far is this notification of the requirements of the Compassionate Use Act to make sure people are notified about that, and that notification or that posting or whatever, that's something we can do. And perhaps this, because it's a land use approach, this addressing this existing mixed use situation, we can do because we're using that approach. So talk to me about our parameters, please, because I'm having a hard time with what we can accomplish here.
Well, yes. Let's talk about the noticing. It is you're stating the law. You're telling people, and ignorance of the law is no excuse. You're telling people what the law already requires of them. But there's no harm in doing that, except that possibly then often people say, well, you didn't tell me I couldn't do this, and therefore you can't enforce it. But for example, the draft LA ordinance, one of its requirements for collectives is that a sign shall be posted in a conspicuous location inside the structure on the property advising the diversion of marijuana for non-medical purposes is a violation of state law. The use of marijuana may impair a person's ability to drive a motor vehicle or operate heavy machinery. And then it goes, loitering at the location of a medical marijuana collective for an illegal purpose is prohibited. This is a sign that they're going to have in their lobby. Again, this is the collective model. I don't think it's inappropriate or necessarily a bad idea to have a sign like that. Again, the only issue is where do you start drawing the line? Because there's a lot of state law requirements, and how many of them do you put on this sign? So.
This is, we have to make a fundamental decision. Do we want to move on to some of the issues that have been discussed and presented by the public, such as a cap and what those caps are, or do we want to get bogged down into the weeds of the basic philosophy of how to implement state law? I think that will shake out, and I think that personally, I feel like we need to move on and tackle some of the issues that we've been asked to do.
It actually sounds like we need to have some direction as to which of these approaches we're going to take. I mean, I'm listening to Mr. Wiley, and what I'm hearing is that there's a fundamental decision that needs to be made by the city, whether we back into it or not, as to whether we're going to take the approach of the collective model or retail model, and whether that's. I mean, I hate to put it to that ultimate kind of decision, but it's real hard to do at ordinance committee.
Well, and the citizens group brought up one that I had thought of separately, which was the idea of instead of the way we do it now, doing a franchise or RFP process where the city just simply chooses the best applicants for a limited number of spaces for dispensaries in the city, where we look at how good of security, how good of record, how good of a site, how good of everything, and we just choose the best applicants among a pool for either what we would consider a city franchise or a request for proposals process. That was suggested by the citizens ordinance that was presented to us, and I thought that was a good process too. But if we do either of those things, it's going to take a lot more work and we're going to have to wait longer for concrete action on the street, and that's what I'm wrestling with. I mean, that there's a part of me at this point who says, yeah, let's do that. Let's go take it back to council. But if we do that, we should do that while honestly realizing that's going to mean there's going to be another month onto the process. So is that what we want to do?
Mr. Chairman, if I may.
Francisco.
I think Mr. House enunciated the same concern that I began with, and that's that we do have a larger picture to look at, and one of the possible things that I think we want to report back to council that they may want to consider is, what are we looking at? Are we looking at a collective model or a dispensary model? So that's a larger issue that I do think we want to take back to council. I'm willing, as I said earlier, as long as we as a committee agree that we will bring up the meta issue to council and hear back from them, I'm okay with proceeding separately on the task that we were originally assigned.
Mr. House.
Okay. With that kind of, I agree. And I think that one of the things we could do that would help our staff at this point and the public is just to go down through some of these numbers that are in our staff report and just see if we can't just knock them off real quick, because some of these are pretty straightforward. For instance, we've heard from the police department about statistics, that they've given us information. I don't think it's...
Mr. House, I'm gonna if we're gonna go down these, I'm going to do it in some order of, in my mind, some of the things that we have been already talking about. So
Right, exactly.
I'm going to take up first the matter of a cap, and what kind of cap we would be recommending to the City Council. We've talked about a cap with regional limitations, and I think that this sort of, if we do this right, it will move us past the problems of spatial considerations of where right now some people are wanting additional spatial considerations, but then we wonder, well, where are they supposed to go? And in my mind, we should probably have, 6 or 7 locations in the city that are where one is permitted and no more. And have a cap of, about 6 or 7. And of course, that will take a little while for that to fall out, because there's about twice as many right now. And because of our other provisions in the ordinance, it will take some time for it to be reduced to that number. But I would suggest 7, and how I've just conceivably brought them up is, 1 on Upper State, 1 on De La Vina corridor, 1 on the Mission Street area, 1 east of State downtown, 1 west of State downtown, 1 on the Milpas corridor, and 1 on the Mesa. Of course, this also means that you need to find property owners that are willing to rent to you, which is at this point very rare. So some of those slots may not be used. But that was my suggestion.
Okay, I support that in case we're taking straw votes right now to piece this together.
And an agreeable solution to recommend for you, Mr. Francisco?
I suppose in the context of this track that I support the idea of a cap. I think the total number 7 is too large for a city of our size.
I don't think all 7 will be used, because I don't think all 7 regions are rentable.
Okay, well, in that case, let's pick a number that's lower than that, like say 4.
Then we are also having to make decisions for the private properties. If you parceled this out, for instance, right now, the Mesa is not rentable, because the entire area that is permitted under our ordinance is owned by one landlord that is not going to rent. And so, a cap of 7, at least while this shopping center is owned by that entity, which has owned it for some time, would actually be a cap of 6. But I also don't feel like we want to get in the business of removing whole areas from it when we are not removing other areas from that cap, such as, the east side. My main thrust with having regional caps is that one area does not become the place that absorbs all of these dispensaries.
Well, okay, how about a regional cap with a total limit of 4?
I personally think that that's a little extreme. I think not by a whole lot, but and if you see, and then the question is, right now, because we have all those areas permitted, which of those areas then do you get in the business of saying there's not going to be one, and which area do you put it in? That's what I'm getting at with terms of fairness. Right now, there's about 7 places in the city where it is permitted, right? The only way, in my mind, to do that fairly is to give that is then to allow 7 slots that Planning Commission does not have to approve, but that but that exist. And otherwise, you're saying, well, we like you over here in this neighborhood, so we're gonna give you one right over here, but we don't like you over here, so we're not going to give you one of them.
I think it might be the reverse, actually.
Well, that's why I was making the joke. So my feeling is because we have those, I think that's an important thing to bring up. I view our large conglomeration downtown as actually being several different sectors, and so that's how I would view it. And I think 7 is a reasonable number, and mind you, it's less than half of it's about half of what we have right now.
True.
So I would say that recommending that, and that would take about 6 months to unfold, would be a pretty rapid progress on the issue.
Okay, here's an alternative.
Okay.
Suppose you say, yes, there are seven regions, but we as a committee feel that 4, assuming that we follow this track, is more than adequate total for the city. And why not just let it happen first come, first serve? It's not easy to get through the approval process on this anyway. And why not just say, we believe that 4 is the most we could possibly need for the city as a whole. These are the 7 regions where such things could be located. And whichever the first 4, 1 per region, gets permitted, that's the end.
Because there's already 3 approved under the ordinance, and there's 2 others in application so we'd essentially be already deciding where they would go, because the ones that have gotten the permit would get entrenched and no others would exist.
Well, we would also be saying, I assume, if the models, no matter what we do, if we cap the number, what that is going to mean is eventually some existing permitted dispensaries are going to go away, change of ownership or whatever condition we impose.
No, because we only have, 2 or 3 permitted at this point? Because we only have 3 permitted at this point, if we had a cap of, in my mind, 4, then we're basically deciding that those 3 get to exist, and that
I see what you mean.
And those are where they're going to go, and that those neighborhoods are going to be stuck with them, and other ones aren't.
That's not what I'm saying. That's not what I'm proposing.
And that would be, but that would be my concern. So what my alternate suggestion is that because we have 7 possible areas, that doesn't mean we have to get to 7 permitted ones. But in the meantime, that means a lot fewer will exist 6 months from now once the non-conforming have to come into conformance.
Mr. Chair, if I may.
Mr. House?
Number one, we can't have it be that there's an unlimited number in the city of Santa Barbara. And the number that may be out there that we don't even know about, that's a whole other issue, and we're going to enforce those. With what we are aware of, a number like 6 or 7, and 7 is a good number for me, I think, because it's a significant reduction to what the potential is, but it also gives us a chance. And I remember, I know that a lot of people, and many people who are here, have a great issue and a problem with these. There are people for whom, and that's the reason we have this compassionate care approach, for whom it's very important that there be legitimate access to decent places, so they don't have to go to some, back of the worst part of town to be able to access something for their needs during cancer treatment. I mean, it's just we need to be able to provide what the law has asked for and what the public has asked for in Proposition 215 and the rest. So I'm saying I think 7 is a right number, at least for us to give a cap. It gives us there's some fairly legitimate operations that are in existence right now working their way through the system. If you set the number at 4, they would not have a chance to be in existence, and yet they're the ones that are models of being literally no problem for the neighborhoods in which they've been operating so far. So I think we need to establish a number that's plausible and doesn't force more into the shadows. I think we need to make sure that this is an appropriate number, and 7 is one I can go for.
Okay. In the this is all a little subjective. I had an incredulous email from someone who said that any less than 12 would be far too few for the city. So there's some kind of subjectivities here. I don't necessarily agree with that statement. I definitely don't agree with that statement. And I think that at least by going with 7, we're going to, within 6 months, have the number in the city. And people will, I'm sure, tell us whether that's enough or not. And I think cutting down half in the city within 6 months would probably be pretty good progress.
Mr. Chairman, I understand your point. I just want to make sure it's clear what it is that I'm proposing.
Sure.
That, okay, 7 regions with a maximum of 1 per region,
right,
and a cap of 4. So that, for instance, if there were existing 2 permitted ones in a region, that's grandfathered, but as soon as there's a change of ownership or whatever other restrictions we apply, then only 1 can operate in that region.
I just think that makes those 4, especially considering that 2 of them are in one region currently, the east side, or are all 3 on the east side.
2 are on Milpas and 1 on Olive.
Right. So there's the 3 existing is in potentially either 2 regions, depending on how we define it, or 1 region. And I just feel like the people are probably not going to change ownership very quickly. And so, trying to get to, an overall cap of 4 seems a little bit unrealistic. I think it should be distributed more widely around the city.
Mr. Chair, Mr. Francisco's suggestion about a cap on the number in any given section or sector of town. How do you feel about that?
Repeat that to me.
So if there were, one of the things we don't want to do is we don't want to have one particular part of town be hosting all the, that was the whole idea, was a more equal distribution throughout the town. If we're going to have the dispensary approach, then there'd be a more equal, so if we were working to achieve a goal of perhaps 1 in each of the different areas of town, that would be something that we could easily set out as a goal right now by having that be a cap in each of the different areas. And there would be a non-conforming status. It would be by attrition that would get resolved in the east side. Otherwise, it would be so if you had 7 total in the city and no more than 1 in any particular area, that means that at least for a while we'd have a non-conforming situation on the east side. But eventually that would, we would expect at some point that might resolve.
So that essentially, as soon as 1 moves out, there still would be no more.
That's right. And then you'd have sort of a blend of your 2 approaches. One is 7 would be the maximum number. That would be the cap. But we actually identify that in these different broad regions of the city, there would ultimately be no more than 1, and that would be a way to minimize any impact in any given neighborhood.
Is that agreeable? Is that a good recommendation or compromise? I'm going to have to go along with some of your guys' ones. So
it's certainly an improvement.
Okay,
it's certainly an improvement.
All right. Let's see what else we can get done in 5 minutes.
Williams, Chair Williams.
Well, we could, or we could get some work done, but I guess you want to have the public comment, so you can comment.
No. I was
Mr. Queta?
a different subject. One of the things that we asked for location-wise was, should we include the area around Cottage Hospital and perhaps Coast Village Road? And if you could just say a definitive yay or nay on that, that would be great.
Well, we'll bring up that issue, but I mean, this is a public hearing, so I do have to take public comment if there are people who wish to speak. So we'll start with Patrick Waddell, followed by Bonnie Raisin, which will mean that this hearing is continued again, because I do think that we have a couple big ones that we can't report out until we get through that.
Thank you. I'll keep this brief. I'd just like to point out that there's been a lot of concern and very little actual statistical correlation showing that any dispensaries are causing any problems. Also, I would ask for you to consider what the cause and effect will be. The cause and effect prior to the ordinance was making more ostentatious dispensaries, which has caught the public's attention. Now, another cause and effect of limiting the number of dispensaries would, one, make it more difficult for the patients to access, two, create a monopoly for cannabis business, and also create a market for people to grow in their own backyards. So this is going to be in residential areas. This will be the alternative. It's spill over. Collectives are nice, but it's a lot of people don't have that type of community to form a collective to deal with their interests, and they're quite complicated under the law. And so just understand that every time you come to what looks like one solution, there's a great likelihood it's going to cause another problem. And if you could think of this while you are coming up with your solutions, perhaps moderation would be better than in extreme measures. Thank you.
Point well taken. Bonnie Raisin, followed by Britta Bartels.
Good afternoon, and thank you for honoring my request to speak. I was a few minutes late. My name is Bonnie Raisin, and I would just like to ask what the resolution has been, if any, regarding the illegal dispensaries. My recollection at one time, there were 15. And are we using the word illegal in conjunction with legal nonconforming? I mean, I'm not clear on this, because with all of the rhetoric and talk about the numbers, I would like to know, and maybe Mr. Martel, could answer the question as to how many illegal dispensaries or places are operating. And
we have to wrap up this hearing, but I'll answer you what the conclusion is on illegal dispensaries.
Well, my next question is, what is, yes, excuse me, and what is being done about them currently? Those are my two questions. How many, and what is being done by law enforcement?
Thank you. Britta Bartels, and while Britta's coming up, because we are going to have to continue this hearing for either next week or in 2 weeks, I do want to say the conclusion on illegal dispensaries, Bonnie, is that they are illegal, and they are therefore not a land use item. We are enforcing on them, and so the question is, in some cases, there's questions of the police department enforcing. In some cases, there's cases of zoning enforcement cases against illegal dispensaries. We are not going to do anything here, I think, to my knowledge, that is going to legalize any of those illegal ones. They are going to remain illegal, and we are going to, as a city, enforce on those. The only gray area is where there is a dispute on whether or not one is non-conforming or is illegal, and that's a question of whether or not they had continuous occupancy of a place. Britta?
Okay, thanks, community members. I just wanted to say something about Dale, what he said about the 4 dispensaries. I think even 4 is still too much for Santa Barbara, so I don't get even close to the thought of 7. And it's just a question of how you deal with the ones that are in progress, giving them maybe some, time to establish, and then maybe 2 years to close down, but no more than 4. I mean, if we want to compare our city to Oakland with 4, we should have like less than 4. And then I'm also here to say something in the name of a Teen Challenge client or victim of drug abuse. She asked me if I could speak up something in her name, and her name is Holly. She is under this program. She started smoking pot when she was 8. She got it from somebody from the high school, and I don't think that there is a question about age right now, because somebody who wants to get it gets it from the brother or sister in a bigger family, which we have a lot here in Santa Barbara. And so we shouldn't write on some 18 or 21 year of age limit. We should more think about how we beef up this whole thing with the numbers, the cap, and if it's like more for recreational use or for the needy patients. We have so far one emergency hospital cottage and one in Goleta, and so the people that have an emergency and have cancer or anything, they can also get a ride over there. And I don't think that we should make it into some kind of liquor store atmosphere where we can have a walking distance to get our medicine. Because, I mean, if you really need it, you can get it somehow. I know people who drive from Templeton to Santa Barbara to pick it up here. So you might want to consider that in form of increasing the distance. Thank you.
Thank you, Britta. I will continue this hearing. We will schedule another one for a week or two. We'll keep on trying to slog through this until we have some strong recommendations. I think we have made some progress today, and we have some good recommendations for the future. I would just also urge people to continue to realize that it is still against the law to sell marijuana. Nothing that we've done in Measure P and nothing that we have in dispensaries. If marijuana is being resold, especially to a minor, it's illegal, and so we can enforce in those cases, and we should enforce in those cases. Again, well, and if you're really just really want to hang out for another hearing, the council hearing itself will start at 2:00.